Thank you very much, Sarah. Our next speaker, Kristyne, would you come up? Michelle's going to get you going with your PowerPoint over here. And while she's doing that, I just want to take a moment to thank all of our sponsors. So if lawyer's title, the rest of you would come up for a minute, and Linda here with Simple Mortgage. And Lauren DePoe, where is she? And Tim Hughes. If you'd all come up just a minute. I just want to say something like this could never happen without a team. And they have been all so great. And we had lunch, oh gosh, I think a couple weeks ago. Lawyer's Title all got together, and we talked about everything. Tim is a commercial title officer up in the Prescott area, does a lot of things with developers, and I must say he's one of the best title officers in the state. I've known him probably for 25 years. And Betsy Letarte has been in the business for many, many years. And she's either a manager or a helper. She does it all, and she is amazing with her knowledge. And Michelle here, I couldn't do this without Michelle. I call her my little blonde bombshell, but she doesn't like that. So she does everything. Last night, her youngest son was in here getting this going on when we couldn't. He's pretty smart, too. And Linda is with Simple Mortgage, and she's going to help us with our Q&A in just a minute. And she's been doing mortgages for years and years. It's a lot of it in Sedona area and all around, and her knowledge is endless. Now, Lauren, come up here a minute. I must say, when I asked to do this event, I think, Lauren, wasn't it about 3 months ago? I come marching into her office, and I said, you guys aren't a school, but I want to do one of these back when we had a different person that has retired. She did that 4 years ago with me. These batteries need to be energy efficient, don't they? So at any rate, I said, I think that Prescott's a school, and why don't we get together and do this with two different associations? I don't know if any association's ever done that in the state before, but Lauren says, sure, I'll work with them. And so she reached out to them, and they reached out to her. And our whole systems went down when everybody was signing up. So she went through Google and got it going on so everybody could sign up. And she's just been so helpful. And I have to, every time somebody changes what they want to do, send it to Lauren, because she's got the list. She always does it. She's always kind, no matter what she's doing. So she's great. And the gal from Prescott, she would have been here, but she's having surgery. And Prescott Association has been wonderful. How many people here are in the Prescott Association? Quite a few of us. How many people are not licensed real estate agents? Raise your hand. Boy, we have a ton of them. And how many are licensed in the Sedona Verde Valley? How many out of Sedona Verde Valley? Quite a few. So we have a big mix. So I hope you all really learn, and that's what this is about, just educating all of us. Thank you so much. Give them a hand. Okay, you going on with the PowerPoint?
Yep, she's ready.
I'm going to introduce you, but okay. I guess I still get this. Gosh, I guess I need my glasses too. Our next speaker is an attorney, and their company specializes in Indian law. And the owner of the company had to be in court all day, and so Kristyne works for the company, And on a short notice, because she had to be in court, she prepared her whole PowerPoint. I think I got it about midnight last night. She busted her butt to get up here. And Kristyne practices primarily in personal injury, product liability, wrongful death, construction, property law. She's also a member of the State Bar of Arizona, State Bar of Nevada, Navajo Nation Bar, because they do a lot of Indian law. She also assists the law firm of Montgomery and Entrepreneur in matters related to water law and the Gila River adjudication. Let's give her a hand.
Thank you, everybody. Hello, hello. As she said, I am an attorney, so I have a tendency to talk a lot and talk very fast. So if I get off on a tangent, just wave your hand, ask me to slow down. I've been doing water law. Actually, I used to do water law through ASU, through the Policy and the Institute. Professor Rhett Larson is where I got my start doing water law. I found a love for it. I've been a litigator since law school. Have found my way back to the adjudication because it is very busy right now. Miss Montgomery, who was going to originally do the talk today, is actually dealing with Gila River adjudication issues, a lot of the settlements and the things that we're going to talk about today. So I will update you on her work and kind of where we're at. So my talk is going to be a lot about the federal reserved water rights, which have an interplay, obviously, with state rights. And so I want to give you a little information about how those two different types of rights play together, and then why that's all important for the Gila River adjudication, the surety that we can get from dealing with the federal rights so that we can all move forward. As a previous presenter was explaining, surety allows us to do the kind of requests that we need to get the water rights we need to develop or to use them. Without surety of what the water rights are for people, we can't do that. It makes it very difficult, and so the settlements are all trying to work that out down in the lower basins right now, and it will soon be hitting up to the Verde. So I think we can probably all agree, water is an essential element of life. You'll hear water is a natural right. Water is a fundamental right. We all have a right to water. We all need it to live. So I'm going to give you a little bit about the foundation of the federal water rights doctrine, and why that is important is the preemption doctrine, which we'll talk about that a little bit as I proceed as well. So the Winters Doctrine was in 1908. It is the case that created basically the Federal Reserved right, and it kind of set forth what we work off of today as far as Federal Reserved water rights. And these rights are explicitly important when they were talking about tribes, because tribes' rights are federal treaty rights. They all come from the doctrine of discovery, back when we originally settled this land, and so now we've played them out into Supreme Court cases, and this is the right that talks about. The Supreme Court concluded that the government, when it created the reservations, intended to deal fairly with the Indians by reserving for them waters without which their lands would have been useless. So there was an implied right to water when these reservations were created. Now, if you know anything about reservations, the Indians don't own the land. And when I say Indian, I'm not trying to be derogatory. Federal Indian law, it's a legal term of art. So anyways, they set these lands. We had the doctrine of discovery. The reservations were created. And so the Supreme Court says, well, when we set aside the reservations for the use by the Native Americans, we also impliedly gave them a right to water. Without water, their land would be useless. So the Supreme Court in that case found it impossible to believe that upon the creation of the Fort Belknap Reservation, that was the reservation this case was specifically dealing with, the Indians who once had command of a vast area of land and the beneficial use of all of its waters would have agreed to become confined to such a small or much smaller reservation, and at the same time agreed to give up their water rights. the very thing that was essential to the reservation's success as a permanent home. These key terms make sense as we kind of will talk about what comes out of the doctrine and how they lay those out. But essentially this case was done at a time after we had the federal removal policy, which was in place when we were originally settling the land, and we had the doctrine of discovery. We were pushing the tribes west, removing them from their traditional homeland, and then we started running out of land. So we started going, well, we need to set these reservations up, set something aside for the Native Americans, and that's what this is talking about, that the tribes would not have agreed to give up their land, give up their rights to water to be removed back to the lands at some point without the right to water also being in place. So the Supreme Court there held the United States, again, impliedly reserves water rights upon the creation of an Indian reservation. That means there's nothing in writing, there's no contract document, there doesn't have to be some special treaty. It's implied in the creation of the reservation itself, so that the reservation can serve as a permanent home and abiding place for tribal people. So essential to the Winters Doctrine was the court's observation that the power of the government to reserve the waters and to exempt them from appropriation, under state law is not denied and could not be. So this basically kind of creates a little bit of a separation between federal water rights and then what states have the power to do within their states of the same water, essentially. The water is in the states as it exists, but the federal government has the preemption power. And this is what that language from the case that sets that up to say the federal government's kind of the overarching preemptor, or has the right to say what happens with these federal water rights secondary to the state. And the state cannot overcome any of the federal powers. This doctrine is why it's important, too, to understand what the federal rights are going to be before we can determine what the state rights are. If the federal government can appropriate water over and above what the state has done, it wouldn't make sense for the state to appropriate the water and then the federal government to come in and say, oh, we don't agree with that, we're going to do it a different way. That undoes, a lot of what would have previously been done by the state. So this kind of, I think, is the highlight to why having tribal rights, having federal rights put in place, having those dealt with before you can deal with state rights is very important. It also provides that the use of the water rights implied for the tribe would necessarily continue through the years. So the setting aside of the permanent homeland, that's the purpose of the reservation, and they have an implied water right to do so. And that is to continue throughout the years. No end date. So lawyers like to debate, we like to argue. And so we like to debate about how the federal reserved water rights doctrine applies under the facts of any particular case. So we say the Winters Doctrine obviously applied to the Fort Belknap Reservation, but this doctrine applies throughout every federal Indian water right that we adjudicate and litigate. So in each case, we're basically arguing the application of the Winters Doctrine for each tribe. Certain principles become consistent throughout each case. Again, federal law governs, and where state law would interfere, again, it must give way. So federal rights trump, federal law trumps where state law is inconsistent. Where state law is consistent with federal law, we obviously don't have a conflict. The priority date, kind of like what the previous speaker was talking about, priority date, first in time, first in right, so the first user is usually first. So it's tied to the date the reservation was created or expanded. Often very early priority dates, if you can imagine in time when we started setting aside reservations, that's when the rights would have then been in place. In some cases, most cases, it would predate Western state rights. Federal Reserve water rights for Indian reservations must necessarily include sufficient water to satisfy both the present and the future needs of the reservation, i.e. the needs of the reservation, again, as a permanent tribal homeland. So these are all doctrines that we can pull out from the earlier language of the Supreme Court case, the Winters case, that are now principles that we have to apply in every case moving forward. So again, water rights are implied, not expressed. If the reservation was created, the water right exists, regardless of whether or not it's in the treaty or in the doctrine that sets aside the reservation. So some of the general attributes, again, Federal Reserve water rights are not dependent on Arizona's requirements. So again, this is why it's important to have the federal rights solidified before you talk about the Arizona's requirements for beneficial use, because the federal rights will trump. Water rights retain their priority despite non-use. So in the state, first in time, first in right, you have to be putting it to beneficial use. Under the federal Winters doctrine, not the case. The water right exists for the tribe, for the reservation, into the foreseeable future, or into the future of the tribe for its population, regardless of whether it's being used. So in these cases, we do a lot of work and research on water studies, trying to determine what those figures are into the foreseeable future, whether it's 10 years, 20 years, depending on what the tribe's doing agriculturally, what their economic growth is. Their population growth does matter when you're talking about Federal Reserve rights, because if you're seeing into foreseeable future, who's going to be there is going to matter. Federal Reserve water rights are held in trust by the United States for the benefit of the Indian tribe, just like tribal land. So again, reservations are not owned by any Indian tribe. They're set aside as a federal land owned by the federal government and leased or in trust for the Indian tribes, kind of like Forest Service. The senior nature and potential size of Federal Reserve rights creates uncertainty for junior users, and I think hopefully you guys are all starting to see why. Creates uncertainty for junior users under state law, even for those who have been using their water for many years, because again, federal rights are not use it or lose it. Historically leading to tension and animosity between tribes and their state-based neighbors, because no one has surety about the water. That's my water. No, that's my water. We all need it. So some of the non-exclusive list of factors considered under Gila River 5 when they were quantifying tribal water rights, or giving factors on how to quantify tribal water rights. Again, future population, residential use, economic or commercial development, industrial use, agricultural production, practically irrigable acreage, which is a standard on how we measure water per acre, tribal use for traditional practices and ceremonies, otherwise known as religious uses, recreational use, wilderness use, the economy of the tribe, and then the tribal history of the water use does play a factor, and is something that we analyze and look at. It just isn't first in time, first in right like the state. Other water rights, that tribes may possess are Aboriginal water rights. This kind of comes out of the water right that predates federal sovereignty, or predates the doctrine of discovery, predates settling, the United States, all of those kind of things. So just the Aboriginal, original sovereign use of water. It's based on continued use and occupancy of the land from time immemorial. Rests on first in time, first in right. So priority date is, again, immemorial. We have no way to quantify that or pick a day. It's It's in history. It's immemorial. They have additional state-based rights acquired through the acquisition of lands with existing state-based water rights. So tribes, while reservations are federal land, have the opportunity and ability to acquire state land, much like we do, own it in what's called fee simple. So that's title where you own it directly, not by the United States. Throughout the doctrine of discovery, there's different the way the land was set aside, depending on the certain federal purpose or intent at the time, depends on how the water or how the land is held, whether it's fee simple, whether it's reservation, whether it's some other type of, aboriginal claim, et cetera, et cetera. So the water rights are going to be dependent on the type of land. So if a tribe goes and buys an adjoining piece of property that's held in fee simple from the state, not a federal reserved piece of land, they can also have state-based water rights in addition to what they would federally have for the reservation. This can include existing ditch rights or other types of state-based rights. So traditionally, federal reserved water rights were viewed as only attaching to the surface, so appropriable waters like rivers and streams. That's to say in contrast to groundwater. It's not an appropriable water unless you have a well, right? So appropriable water is flowing waters on the land. Recently, case law, however, recognizes that federal reserved water rights should attach to any water resource that's available for the tribe, including groundwater, to fulfill the purpose of the reservation as permanent tribal homeland. And this goes back again, you're seeing that reoccurring theme, that comes out of Winters, the permanent tribal homeland. In other competing interests, obviously tribes are not the only ones with federal reserved water rights. So you also have to consider what the U.S. Forest Service, different federal rights, they also have rights to water in the same capacity as a tribe would. It's a federally reserved right. So any kind of parks that we've set aside, military bases, those type of federal locations all also have federal reserved water rights that need to be rectified, remedied in these before state adjudication claims. So there are thousands of state and federal claims in the Verde River watershed. The 5 different sub-watersheds that we're talking about in the Verde River watershed are the Big Chino, pictured there on the top. Then we have the Little Chino down here, the Lower Verde Valley, Sycamore Canyon, and then the Verde Canyon down here to the south. So the tribes that are in that watershed are the Yavapai Apache Nation, the Yavapai Prescott, the Fort McDowell Yavapai Nation, the Salt River Pima Maricopa Indian Tribe, which is at the confluence of the Verde and the Salt River. Other federal claims for that I've mentioned previously, the Forest Service, National Park Service, all of those types of claims exist in the Verde watershed. So all of these claims, again, the federal and the state claims, will have to be resolved by the adjudication court in one comprehensive proceeding. In 2001, the Arizona Supreme Court urged the state and the tribal parties to work together to resolve the numerous outstanding federal reserved water rights in Arizona. In Gila River 5, the court was quoted as saying, "It is our hope that interested parties will work together in a spirit of cooperation, not antagonism. This is especially so now when the welfare and progress of our indigenous population is inextricably tied to and inseparable from the welfare and progress of the entire state. In 2019, a committee within the GWAICC concluded that the settlement of unresolved tribal water rights claims is important, not only from the perspective of justice for Native communities, but also in terms of assessing statewide water availability. In the absence of settlement, many Arizona communities remain uncertain as to the full scope of their water supply. And we can see why, right? Federal rights trump. Since early priority tribal rights remain unsolved. So this is kind of giving you a little bit of doctrine where the court recognizes that obviously resolution of these tribal water rights are not only important for the welfare of the tribe, but it's also important for the understanding of the Arizona community's water rights and what those look like. And we can't have one resolved without the other. Here are some of the Indian water rights settlements. This is a little outdated, but all of these tribes at this time have settled or settlements that are being finalized in place, except for the Yavapai Apache Nation, and that's what Sue Montgomery is out of commission today, trying to work through, and so we're still trying to work on that final piece of the puzzle. Additional settlement for the tribes so that we can keep moving forward in the adjudication, having more surety for the tribal water rights. This slide is not to scare everybody. It's just kind of a highlight on another reason why settlement is important. While I agree with our previous presenter that it's likely not overuse, it seems that we've, as progression happens, we become more efficient with water use. We have more methods and ways to deal with water use, and so it could be evaporation, increasing temperatures, those kind of things. But when something like this happens, and we hear there's mega droughts, that there's issues with the Colorado River, that feeds into a lot of the states, California, Arizona, the tribes, of course, all of the residents of all of those nations and the states. So it's important that we all work together in the spirit of cooperation between the tribes, between the states, between the federal government, so that we can all take care of these resources and keep moving forward with our water rights into surety. And that's what we're hoping to try to keep accomplishing with the adjudication. We are litigators, so it is contentious at times, but we all, I think, share the spirit of moving forward in cooperation. So the importance or the benefit, the greater benefit of using a settlement versus just going through a trial and adjudicating a water right is that it removes uncertainty about water for all the parties. So you're being able to kind of buy yourself clarity, surety, under the terms that you can live with or without, or hopefully some balance in between, rather than putting the claims through the true adjudication process where you don't really have a control of the outcome, right? You have a person who's the adjudicator who gets to determine your right, with you, of course, arguing with the opposing claimants. Whereas settlement, though, you kind of have a black and white piece of paper where you get to buy some surety for all the parties involved. Everybody gets to come to the table and discuss what each person can live or live without. They're not just paper water rights. So if you can imagine that water rights, what you might have on a piece of paper in actual practicality may not be consistent. So settlements give you an opportunity and ability to make sure that your actual water rights, you're actually getting water to the tribe, to the state, to whatever programs need the water, rather than an adjudicated right that maybe at the end is not reasonably able to be fulfilled because of infrastructure or something else. So there might be another created layer. Congressional funding, I just kind of mentioned that, for water infrastructure and other projects that benefit the tribes off reservation neighboring communities and the state as a whole. So you have to have a surety of your water rights, or at least be able to say what you're going to do or what you have before the federal government will give you money to build something that you might not even have a water right for. What would be the point in building something if you can't legally get water there? So the federal government, usually in granting, wants to make sure that you have the right before they are going to fund. So the settlements give you a concrete right that allows you to then get the funding that you need. It allows for allocation of scarce water resources unrestrained by the doctrine of prior appropriation. It fosters cooperation, creative solutions, and partnerships. Okay, that's all I have.
Thank you so much, Kristyne. I don't know when you had to get up to come up here, but we appreciate you. Now next, Kristyne has to go back down to a litigation, I guess it is, in the Phoenix area. So we're going to have, we might not have all of a half hour, but we're going to have Q&A. Now, if you can take this down, any question you have for both presenters, you can text it to, and it's on our screen, the first one that was in, and you can even do it afterwards because you'll get it on a PDF. It is 928-900-3506. That's 928-900-3506. That comes into my Google account, and you'll get that text. So if we can't cover it right now, you'll get your question answered. So what we're going to do to save time, because we're about 15 minutes out, Linda is going to go around with a mic, and Michelle will go around with a mic, and Elijah's going to get a mic over here to the two presenters. I'm not going to have a mic. So if you can stand up if you have a question, and they'll come around to you. Just stand up.
For Kristyne, are the tribal rights the most superior water right?
Federal rights are the most superior water right, and that includes national parks, military bases, any kind of federal lands have federal rights. So I wouldn't say no, the tribal right isn't most superior. It's any federal right.
You had a slide on of all the tribal things that had come to settlement. The only one not being there was Yavapai Apache. Any comment or explanation of how that's going so slow, or do they now, come on, let's talk bluntly here, since the adjudication is going on, are they in a holding pattern until, are they in a better position just to wait than to settle? And can you, a little bit of history, were those settlements of those other tribes recent, or has that been going on for a lot of time?
It's been going on for a lot of time. So if you imagine that Gila River, those cases kind of started coming out in the 70s and 80s, these water rights claims have taken that long to even start to understand the fundamental basis of what water law is and what it's going to be in Arizona. So naturally, from those doctrines, then we start thinking about how practically do the states, do the tribes, do the claimants now create a system for that to play out. And that's been playing out since Gila River was adjudicated. So I think it's partly a progression of the fact that the case law just kind of started in the 80s. It seems like a long time ago, but when you're dealing with different tribes, you have, different governmental entities. There's a congressional, component to all of that that plays out. So I don't think that there's any reason for, contentious reason why there hasn't been a resolution. It's just the final one that's in the works.
Arizona was able to settle quite a number of very significant in the way of other water users' tribal claims when the CAP was built. slightly more than half of CAP water is allocated to tribes. And so that helped immensely with that list that Kristyne had.
Do you see homestead land patents treated any differently than things that are like in the deed and title system as far as when those land patents were given to individuals based off of when the tribe treaties were made? Like, do you see anything different with land patents versus deed and title?
Yes, because there's a different factor in play. So every case is not the same. Speak more in the mic, sorry. So it's state-based rights, again, are first in time, first in rights. You're going to look at when those homestead documents were filed. It's going to be a complete case analysis, basis to basis. But then the Federal Reserve water right is kind of the trump to all that too, which is a reason why these settlements are so important. We have, a piece of the water, if you imagine, upstream users, downstream users, and maybe the downstream user might have an earlier date and time, but the upstream user is using the water, or the tribe is upstream and it has a higher, federal right. So you have to consider all of those types of rights when you're doing resolutions, which is why that's important.
So in Cornville, there's quite a few of us that are reverted back to the original land patent homesteads. So when something like this is going on, the settlement talks are happening, is that something when once settlement is reached, is that something that then blankets all people in the Verde Valley? Like, are we all under that one umbrella? Or does each group need to reach their own settlement? Like, do we need to go talk to the tribe ourselves and reach our own settlement? Or is that something that would be encompassed in the current efforts?
So it's encompassed in the adjudication. The surety of the water right just kind of gives the foundation for where everybody kind of falls. So if you are going to stake your water rights claim, there's a whole process that you have to go through in the adjudication to do that. Every individual claimant makes their own claim, including the tribes. The tribes make their claims, the individual, persons make their claims, and then throughout that adjudication process, in each claim, you have separate negotiations, separate resolutions for the people that may all be affected by that specific shed area.
Are the claims still open for our area? Like, is the time frame to put in a claim still open,
I
or
don't
is that
believe the
closed?
claims up here have even started. So we're still trying to resolve the ones down in Phoenix. We're still in the Gila River adjudication. Back in October, I believe it was, of maybe 2021, there was a pamphlet or a flyer that went out about they're creating the hydro survey water report. I'm sorry, no, did I say it correctly? Hydrographic survey, thank you. And letting people know that that's going to be available and you can make comment on it. So I would say, pay attention to what's in the mail. Do your own little research through the water departments, through ADWR, those, through people that are up to date on where the adjudications are, and that will help you know.
Thank you.
The Department of Water Resources is the technical expert for the court, and they manage the statements of claim. So everybody who is asserting a water right files a statement of claim, and there's a lot of very helpful information on the adjudications pages of the Arizona Department of Water Resources. It's azwater.gov. Click programs and go to the adjudications area, and you can find a lot of helpful information.
Thank you.
Hi. The town that I work for supplies water to a tribal area. Obviously, the tribal area's water rights will predate the town's. Once the tribal rights have been established and agreed upon, is there going to be room for negotiation between towns and tribal entities to secure those rights or make some kind of an agreement where the tribal priority can be used to assure the town water supply so we can continue to supply the tribe? Thank you.
That's what it's all about. So down in Phoenix right now, that's what we're doing. So we're working with a couple of tribes down there who have CAP water, who have contracts with other tribes who actually assure their water supply too. So that's part of the kind of ideal is who are all the interested water users and bringing them together in those areas to work together for whatever that makes sense to them and working out those negotiations.
There's a rumor going around that they're going to be putting meter on residential wells. Is that a possibility?
That's a rumor.
Yeah.
Residential wells aren't even metered in the AMAs, so I wouldn't worry about that.
I have a
Yeah.
well drilling company, been here for 50 years, and that's the answer I've been given to. I don't see how that in statute they could do that.
I mean, just to be clear, the legislature of Arizona has the authority to regulate groundwater and groundwater use. There's an Arizona State Supreme Court case that says that. So they could require everyone to do it, but it's a very unpopular idea, and I don't think it's ever going to happen. Not residential wells. Big wells, yes, not residential.
Hi. With surface water, I think traditionally it was like fair use if it's navigable waters. Is that still the case, and what defines navigable?
Navigable is what it sounds like. It has to do with whether a watercraft could make its
Does
make
a
its way.
kayak count?
But navigable waters has very little to do with the issues that we're talking about, which is navigable waters is a standard for jurisdiction, ownership of the riverbed, and Clean Water Act pollution, whether the feds have authority to regulate pollution. It is not really at issue, I would say, in the adjudication. Has nothing really, I don't think, anything to do with the adjudication.
I would just add that I added that information for informational purposes, just so that you guys can kind of understand the distinction between the language of the federal water rights versus state.
I have a question. You mentioned that the tribal use is dependent on what they expect as far as the future tribal growth. Does that take into account only the people living on the reservation or members of the tribe?
That's an interesting question. And this is how we deal with it. So when we're working for the tribes, of course, we want to consider into the future, people that are off reservation, because those are communities that are kind of like the center, whether you want to consider it a religious right, a tribal right for them to care for their people. So there are some tribes, depending on how they are set up or how they were federally recognized and when, if their population has been dispersed interconnectedly throughout the state, which goes back to those fee lands. It goes back to previous policy when we were doing the doctrine of discovery, so it's not really a one-size-fits-all. We consider population growth. We look at all those factors when we do the land surveys, when we do the water surveys. We consider how many people are on the res, how many women are likely to give birth to additional children on the res, who are in the outlying areas that are tribal members, are enrolled tribal members, and we put all that information into.
So can enrolled tribal members always have the right to come back to the reservation? Because that seems pertinent.
Yes. Policy, theoretically, yes. Yeah. But for purposes of quantifying water, yes.
Question for Sarah. So the water augmentation, importing water into the state, I would assume a lot of that is being kept very hush-hush, so that if you were negotiating bringing river water from another state in, because I've heard of such things.
Yeah, I am pretty sure there is no ongoing development in the way of the options. All the options that I had
Right.
up are actually being scoped. They may be at some point of permitting, of actual NEPA evaluation or permitting or being piloted, all of those options. That is not the case with there's an idea out there of importing the intermittent floodwaters of the Mississippi or the Missouri River.
Right.
That is not underway in the way that the options I had up. And I just want to say one thing about the Mississippi River. Between Phoenix and the Mississippi River, there are a whole lot of water customers along the way. And so to just be real, it could happen, never say never, but we're talking about something that would involve new partnerships with a bunch of new states, the aquifer that, you know, that this concept would run through. The Ogallala is famously being dewatered in a, you know, region that it has no other water supply. And we also have 50 years of environmental regulations that didn't exist when the CAP was built. So there are challenges for that concept that make the concepts that I had up here arguably more attractive, including that it's, most of those concepts could all be done by the state of Arizona alone, without having to involve other states.
Okay, I'd like your take on this one, and that is, I'll just admit it. I've told clients and friends who have land that is eligible for a well, drill it now before the adjudication hammer comes down, because if you don't have your well in the ground, you're going to be out of luck.
Well,
Hung out to
I'll
dry,
tell
so
you
to
my
speak.
take. You should give your clients that report, The Price of Uncertainty. And I think we'll hear more from the other speakers about this. The fact that you have a well, if we're talking about the adjudication, your well does not save you. You may be pumping out subsurface flow of a river that you, the well owner, doesn't have a right to, because they are not a senior user. So I personally don't think run out and drill a well would be the advice I would give. I mean, I can come up with other arguments. You know, my sense is that the bigger parties in the adjudication in the Verde don't want to cut off people's residential wells. So, you know, I think that there may be other solutions for such folks, but just as far as, you know, do they have a legal right to the water at the end of the adjudication, to the water from a well? That is not, that's not necessarily a good investment. I would say, I would give them our report instead.
You talked about the federal water rights trump all, the federal rights trump all, and you talked about the different areas in the state that are federally owned, the military bases and things. So what about an area that was recently dedicated to federal land, like the federal monument that President Biden recently did? Does that now trump everything because it's now federal land?
Yes.
When it was, so it doesn't matter when they acquired it.
Well, there's a date.
So the
Two.
date that they acquired it wouldn't trump maybe my water rights if I have them, because I've had mine longer than when that became a federal property.
Yes, but the federal water rights trump, and they don't have the first in time, first and right beneficial use. They don't have to be using it. That's the distinction. So if you have a state claim that was done in 1960, and you're using that water, yeah, then you're first in time and you're putting it to beneficial use, right? Then this federal right comes later. It's going to have a later priority date, but it still has a right. And back to the other question too, I would say go to the ADWR website, file the state. You need to file your statement of claims. You need to file your statement of claimants. You need to get those things moving forward to have a water right. Just drilling a well is not going to do it for you.
Just one more question. So based on all of the things that we were talking about, I think what I have a question about is whether we're solving the right problems, because it feels like the adjudication needs to happen in order to be able to solve the right problems, because based on some other water talks that we've had, water doesn't seem to be the issue itself. It's the allocation of the water rights and then distribution of the water to areas where it's needed. Is that correct?
I'd say that's a piece of the puzzle, yes.
Okay, so for
Can I
instance,
just add to that?
Sure.
You know, you just hit on something that's so important, which is that no one has control of their destiny. I know there are people here who want to see economic development. There are people here who want to make sure that the Verde River keeps running. No one, you can't accomplish any of those things until you settle the claims in the adjudication. It is the critical path to being able to realize any of those aspirations, not to mention additional water infrastructure.
right, because I think that infrastructure is what we're going for here in the end, because I don't think that the actual water itself, we're not running out of water right now. That's up and down, that goes up and down all the time. So I think everyone's so worried about like you know, assured water supply, absolutely. But I think it's really more about sharing the water in the right places so that everyone has an assured water supply over, you know, the years or whatever you want to say that is. So,
And I think it goes back to, right, manifest destiny, doctrine of discovery. The West was settled last. Now it's all playing out. We're just in it. We're in it. The East Coast is done. We're in it now. And now
may
we're
or
all
may not be
figuring
able
out what
to.
does the West Coast look like.
Stand up in the middle.
And we're getting our water rates quantified.
Sneaking in on Ron's, can you folks talk about de minimis water and how that might work out with our wells?
So that goes back to claims. In the adjudication, all of the claims have to be considered. There are legal doctrines about what's considered de minimis. So we review the water rights. Let me give you a little example about how we review a case when it comes in. A claim gets filed. We know that there is another water right on the riverbed that our client might be also having a right to. We look at it. Is it de minimis? Is it stock watering? What type of use is it? And then everybody all gets the same information. And we all start going, okay, who's the bigger uses? Who's the littler uses? What are the claims that we can settle first? And which ones are we going to be kind of hammering out a little bit for a while and trying to work out? That's how that kind of plays out in practicality.
In the rule, the Supreme Court rule on subsurface flow or subflow, which is the ruling that says some of the water that's being pumped up in wells, if it is subsurface flows of the river, then it's surface water, and it comes into the adjudication. The court says de minimis users don't have to come in, but it's still somewhat, it's not completely decided what that means. So you can't count on the fact that it's a residential well or my little stock pond. Some of that is still really yet to be determined.
I know this is a very unfair question, but a lot of this adjudication has been settled. What % has been settled, and when do you think the rest of it might be adjudicated or settled?
If you saw my email, you would not believe it. You can't look at all of the claims that are rolling and pending on one page. I mean, you have to click next, more. I have to download it from the cloud. And then some are coming in as more are going out, and it's just, you know, I think the case numbers are somewhere in like the 3,000s or something. I don't know. I'm saying off the top of my head, or maybe it's 11 something. I don't know. Yeah. Like 1,100 and something, and that's just for the Verde. We haven't even got started up here yet. So, and there's really no timeline on when they settle. Some of them are settling, you know. Sometimes I'm sending out an email going, okay, we got a deal on 3 in the morning, and 4 more pop up, and I'm fighting about those in the afternoon. There's a lot.
Go ahead.
I have a question. The farmland that's being sold to foreign entities with water rights, what are we doing to make sure our water rights are being protected when that land gets sold again?
Well, you know, it is, let me just say, it is legal in Arizona for a buyer to come in and buy land, and if it's outside of the blobs, remember the green blobs and the orange blobs, drill a well and use that water to grow whatever they want to grow, or have a catfish farm, or do whatever they want to do. Whether they are, and by the way, the vast majority of alfalfa, that's the trigger crop that's grown in Arizona, is grown by Arizona farmers, and they export, their biggest importer of alfalfa is China. Saudi Arabia is second. So to me, this isn't a foreign ownership problem as much as a problem that we have communities in those areas outside the blobs who don't have protection of groundwater as a long-term reliable water resource. The legislature has the power to protect them. There's discussion of creating a kind of framework that would allow communities to develop their own form of groundwater protection. I think that's kind of nice because it gives local communities, you know, the control over their destiny. But this is really, it is often in the papers as foreign companies coming in to do this, but you know, our basin that is in the most trouble is down in southeastern Arizona, in Wilcox, in Cochise County, And it's a Minnesota dairy that's running a giant alfalfa operation, and people's wells are going dry. Do you feel better about it being a dairy from Minnesota than a dairy from Saudi Arabia? Or, I think if your well goes dry, you don't really care the provenance of who caused your well to go dry. It's really up to the legislature to regulate the use of groundwater.
So when the owners are filling out their statement of claim and you have to put the chain of ownership down, what happens if you can't follow that full chain of ownership? Then is that current owner at risk of losing their rights?
Yes and no.
Okay.
The big key, it is. Welcome to the law. So that's why we have so much fun. There are cases where statement of claims have been filed and there's been no underlying statement of claimant, and then that's part of the negotiation process, right? Like, sure, we'll all go along with whatever, depending on how much water it is, depending on whatever else. But the big thing is file the statement of claimant, regardless. Go pull your historical documents, get it all in. Start the ball rolling so that those things can be assessed and be finalized in some way. And if there are those snafus, we deal with them as the case comes. We all try to put our heads together, which is why the spirit of cooperation is so important.
So typically when you bring a case against somebody, you have the burden of proof that you have to prove whatever you're claiming. So they're claiming I'm pumping river flow water from my well, but they're not taking into consideration all these different factors, like a chemical analysis, where my static shut-in head is, where the casing goes to, all of those things. Why am I responsible to prove that? Why isn't there a tracker in the water or some method to prove that I'm taking river flow?
If I was a politician, I might be able to answer that. That's part of kind of what we work out too, is who's claiming what water and where is it coming from. There is a fundamental issue of who should pay for those things, and those come out in some of these adjudication claims too. Like when we have for a stock pond that's huge and it's using more water than it's claiming, and we're all talking about, well, the adjudicator's like, well, we need to send somebody out to quantify that. And then we're kind of like, well, we already did this a few years ago, and now the other master already said we don't have to do that, and now we need to send somebody out for $5,000, $10,000. Who's going to pay for it? But if you bring a claim, you got to prove that your use of the raw water, and that's why I think it ends up falling on the claimant.
If you're sued, I used to do defense litigation, complex commercial litigation defense. I was like an oncologist. No one ever liked me. I was the last person they wanted to. But the reality of the judicial process is that the defendant also sometimes has to prove some stuff. And so that's how this breaks. The Supreme Court has set a rule for what constitutes subsurface flow. And the Department of Water Resources is responsible for mapping that in the hydrographic survey. And then you, as a person with a well who want to contest that, have the opportunity to contest that. Lawsuits suck. They're terrible, but it's the best process we have for resolving conflict.
And I could just add to that too, because I am still a defense attorney, and when my contractors come to me and say I've been sued, I say, okay, well, here's $5,000, go hire that engineer, because we're going to need him.
So the town that I work for has a designation of adequate supply. We have multiple wells that are part of that designation. One of the wells has gone dry. There is a statement of claim for that well. If we need to drill another well, can we transfer the claim for the volume for the dry well to the new well? And does the new well have its own brand new priority date within that designation of adequate supply?
Good one.
So that's rights versus claims, use versus all of that, right? The paper versus the water. So I would definitely take that to whomever regulates the well, your original paperwork. and try to get that accomplished. Yes, in theory, if you have a right, a claim to water, you have the claim to that water on your property. Whether you have a this well or this well is really, it doesn't matter, as long as you're not taking more than you have a right to, more than you have the claim to, the paper claim.
Folks, if we want to stay on track, from here on out, if there's something very important, but text your questions to 928-900-3506. We've got to get on to our next speaker. Is there anything vitally important before we head to our next speaker?
Just one more.
Anything else?
Just one more. How does it work if people have water rights through, like, say, the Cottonwood Ditch Association, and you have a share of the Cottonwood Ditch Association water rights? Do you have to make your own specific claim, or are you just part of the association?
I think the SRP folks are going to cover that. I'm punting the ball. Thank you all for your patience and your attention.